This is Bergman versus Maestro Health and Group Associates, Inc., docket number 20-640CB. This is the time set for hearing on the defendant's motion for summary disposition. And I'll take appearances first, please. We can start with the plaintiff.
Good afternoon, Your Honor. Michael Behan on behalf of the plaintiff, Alan Bergman.
Good afternoon, Your Honor. This is Jennifer Jackman on behalf of defendants.
Good afternoon, Your Honor. Natasha King on behalf of the defendants.
Okay, then it is the defendant's motion. Whichever one of you is taking it, I'll hear from you first.
Great, thank you. Good afternoon, Your Honor. I'm Jennifer Jackman, and I'm present today with my colleague, Natasha King, on behalf of defendants. And as you just said, we're here today on Maestro Health or defendant's motion for summary disposition. As set forth in our pleading, the facts in this case are quite simple. They do not require discovery in order to adjudicate this case, and judgment should be entered in favor of Maestro Health and defendants. The Michigan Supreme Court has already spoken on the issue that is before Your Honor. That is whether the event of a non-renewal of a contract triggers the obligation to pay severance as a termination without cause, and they've held that it does not, and affirmed the trial court's grant of summary disposition in favor of the employer. The plaintiff's complaint is pretty simple and alleges a single cause of action for breach of contract arising out of an employment agreement he entered into with his employer in 2015. In 2020, Maestro provided notice to Mr. Bergman that it would not be renewing his contract for an additional term and that his employment would end when the contract term expired. Plaintiff claims that Maestro Health has breached the contract by not paying him severance after his contract ended. The agreement, which is attached as Exhibit A to plaintiff's complaint, states very clearly that severance is only to be paid if the contract is terminated without cause, and the critical terms are during the term of the contract. The initial term of the employment agreement was 3 years, and it was automatically renewed for 1-year terms unless notice was provided at least 30 days prior to the expiration of that term, and in which case that agreement would not be renewed. The word term is defined in paragraph 2 as including both the initial 3-year term and any subsequent renewal terms that were 1 year. On February 20th, 2020, Maestro provided written notice to Mr. Bergman it would not be renewing the agreement for an additional term, and that instead the contract would end on June 29th, 2020, which was the end of the then current term. This notice to Mr. Bergman was very clear that he was not being terminated and that Maestro expected him to continue working through the end of the term. This notice of non-renewal also offered Mr. Bergman the option to resign if he wanted to before the end of the term, and he would still be paid through the end of the term without any penalty. Mr. Bergman chose not to resign and instead worked through the end of the term, and he was paid through the end of the term. Paragraph 5C of the agreement sets forth the parties' obligations if the agreement was terminated by Maestro Health without cause during the term. Mr. Bergman relies upon this paragraph in support of his claim that he is owed severance. And the key language in that provision is that inclusion of the language during the term. That provision is clear that severance is only to be paid if the agreement is terminated during the term. Because the contract was not terminated during the term and instead was simply not renewed at the expiration of the term, paragraph 5C and its obligations are not triggered. The contract is very clear that termination and non-renewal are very different and treated differently and are dealt with separately in 2 different provisions. When interpreting contracts, though, you can't just review one of the provisions and try to apply it without reviewing everything. The terms of the contract must be read together. And in this case, when paragraph 2 and paragraph 5 are read together, it is clear that paragraph 2 provides the means for choosing not to renew the agreement at 1-year intervals, and section 5 provides a means for ending the relationship at any time between those 1-year intervals. Non-renewal under paragraph 2 just does not trigger severance, while termination under 5C does. It's undisputed in this case and in the record before Your Honor that Maestro Health gave Mr. Bergman timely notice of non-renewal of the agreement. It is also undisputed that Maestro Health allowed Mr. Bergman to continue working through the end of the contract term and paid him his full salary through the end of the contract term, which expired on June 29th, 2020. The law presumes that the contracting party's intent is embodied in the actual words used in the contract itself. And absent an ambiguity, the court may not consider extraneous evidence. The provisions at issue in this case are not ambiguous. To be considered ambiguous, they have to have two or more reasonable interpretations. Importantly, no alternative or no reasonable alternative interpretation has been identified by Mr. Bergman. I would proffer that this is because there is no reasonable alternative interpretation of these provisions. In support of our argument that the contract terms are unambiguous, we cited to several cases that dealt with similar provisions that treated non-renewals as different events from terminations without cause, so that the obligation to pay any money was not triggered. Notably, Mr. Bergman has not cited to a single case that has found these terms to be ambiguous, capable of any different meaning, or requiring the payment of severance. For example, in one case we cited just for persuasive value, which is Perry versus Community Action Services, the United States District Court for the Northern District of Illinois squarely rejected the plaintiff's argument that he was entitled to severance if his agreement was not renewed. Like the contract at issue in our case, that court noted that the provision on severance made no mention of non-renewal, and the portion of the agreement dealing with renewal did not define non-renewal as a quote unquote termination. The court went on to state that termination and non-renewal are not generally interchangeable in common contract parlance or business practice, nor is severance generally received upon non-renewal of a contract. As the court likely noted, the agreement, in our agreement, provides for the application of Delaware law. In support of our motion, we cited Equity Trust versus Interactive Brokers, a Delaware case that considered whether a non-renewal should be treated differently than a termination provision, which does require the payment of certain fees. The court in that case held that if the plaintiff wanted the non-renewal of the agreement to result in the automatic payment of fees, it should have included those express terms in the agreement. And because those terms were not included, the plaintiff was not entitled to payment of fees upon non-renewal. If we apply that reasoning and the Equity Trust case to our case, if the parties intended to require severance in the event of non-renewal, they would have and should have stated. The parties would not have limited the requirement to pay severance for termination with the language during the term of the contract if they intended to include non-renewals. Instead, they would have expressly included non-renewal in the severance provisions. They also would not have treated non-renewal as a separate issue in paragraph 2. In the event this case orders Michigan, in the event this court considers Michigan law, the Polera versus STC broadcasting case requires granting our motion for summary disposition. In Polera, the plaintiff argued that the employer's notice of non-renewal operated as a termination without cause, triggering the requirement to pay severance. The Supreme Court of Michigan held that summary disposition for the employer was appropriate, holding in that case that the employer did not owe any severance because, like in our case, plaintiff worked through the end of the contract term. In a very short opinion, the Supreme Court noted, and I quote, "It is undisputed that the plaintiff worked for the duration of this period and the defendant paid plaintiff for his work during this period. Defendant, therefore, had no obligation under the employment contract to pay plaintiff a severance." The court then relied on New Amsterdam Casualty versus Sokolowski that holds, if the language of the contract is clear and unambiguous, it is to be construed according to its plain sense and meaning. Mr. Bergman has not cited a single case that requires a different outcome under any jurisdiction, let alone Delaware or Michigan. As such, the holding in the Polera case must be applied here. Instead, Mr. Bergman has improperly relied nearly entirely on extraneous information in his opposition, And this is, in my view, this is putting the cart in front of the horse, since he has not identified an ambiguity, and the case law is clear that in the circumstance there is none. Not only should extraneous information not be considered by this court due to the lack of any identified ambiguity in the contract, the information that the plaintiff is attempting to rely on is not evidence that's even properly before the court. Mr. Bergman purportedly contacted a couple of former Maestro Health employees to offer some support for his cause. Mr. Bergman did not, however, provide any affidavits from those former employees, and instead attempts to rely upon his own affidavit, attesting that he received these emails as a way to try to get that evidence before the court. These emails constitute inadmissible hearsay, and there's no exception to the hearsay rule that would allow their admission. Had Mr. Bergman wanted this information to be considered by the court, he was required to obtain affidavits from those individuals, which he did not, as far as we know. Moreover, again, even if this was not hearsay, absent an ambiguity, evidence of intent should not be considered. Because the contract is clear that severance is not owed when the contract term ends, plaintiff argues alternatively that he was actually terminated during the term. Like Polera, the undisputed record before this court shows that Mr. Bergman was not terminated during the term of the contract. Instead, what the undisputed record is showing is that on February 20th, 2020, Maestro provided written notice that it was not going to extend the contract term, and clearly and unequivocally told plaintiff that the notice is not a termination of the agreement, and Maestro expects you to continue to work and to be paid through the end of the term unless you opt to resign before the end of the term without penalty. And that letter is attached to our motion as Exhibit 1. The undisputed record also shows that on April 27th, 2020, Maestro sent plaintiff a final written notice of intention not to extend the term of his agreement, again notifying him that the agreement would expire on June 29th and would not be renewed for another term. That letter is part of the record as Exhibit 3 to our motion. Plaintiff's attempt to muddy the water by alleging that his supervisor told him that his employment would be terminated, which he spent many pages kind of going through some history, does not change the fact that his employment was not, in fact, terminated during the term. Again, and I'm trying not to beat a dead horse, but it's undisputed that Mr. Bergman worked through and was paid through June 29, 2020, which was the final day of the contract term. Although Maestro Health did undergo a reduction in force in February 2020, Mr. Bergman was not included in that reduction. Instead, Maestro made the decision to allow him to complete his contract term. Maestro Health was only required to give him the 30 days of notice, but in an attempt to be transparent and to allow him time to prepare for his future, Maestro provided him with nearly 3 times the required notice that his contract was not going to be renewed. They could have easily waited until the end of May to notify him, but decided they did not want to do that so that they could provide, so he could plan accordingly over the next few months. But as an alternative theory, plaintiff now avers that the severance pay was intended to be consideration for the non-compete provision, so long as he did not resign and was not terminated for cause. That argument is also belied by the actual language in the agreement itself. If you look at paragraph 6, it includes the non-compete provision and states that consideration for the non-compete was, quote unquote, the offer of employment. Notably, there is absolutely no mention of severance as being consideration for the agreement to not compete. If the parties intended that severance would be a condition precedent to the duty to not to compete, that would be triggered anytime Mr. Bergman's employment ended, but the agreement does not provide for that. As Mr. Bergman has not met his burden in showing the existence of an ambiguity, all of the extraneous evidence that's relating to intent, to whatever other conversations he's had, should not be considered. And because it's undisputed that Mr. Bergman worked through the end of the term of his contract and only stopped working when the contract was not renewed, he is not entitled to severance under the clear language of the agreement. And in that situation, Polera should be applied in this case, and summary disposition should be granted in favor of Maestro Health.
All right, thank you. Mr. Behan?
Thank you. Good afternoon, Your Honor. Quite frankly, I listened and didn't hear much, if anything, that was different than what was.
Wait,
I'm getting a lot of feedback.
You're getting feedback?
Yes,
I'm not hearing it.
I'm getting it through my headphones. I don't know if he wants to turn his volume down just a tad.
The court recorder is getting a lot of feedback through her headphones. She thinks maybe Mr. Behan, if you turn your volume down a little bit.
I can do that.
And I'm going to make sure I'm muted in case.
Yeah, that helps too. Mm-hmm.
Thank you.
Is that better?
Yes.
Yes, she says it is. I'm sorry. Could you start over?
I would be more than happy to. Again, good afternoon. I'm Mike Behan on behalf of the plaintiff. And what I was saying, and I'll restate, was I frankly didn't hear anything different than what was presented in the brief, with a couple things that I will respond to, because I found them to be of interest, I suppose, and that is clearly under the law, evidence of what the intent of the contract is germane, it is relevant, and that is why when Mr. Bergman was discussing the issue raised by the defendant with the two individuals that were most responsible for the actual agreement that was memorialized ultimately in this written contract, we attached those emails because I think it shows what intent existed at the time that contract was negotiated. And given the unique situation of a defendant, as is their right, seeking summary disposition prior to any discovery being taken, I certainly would like the opportunity to depose both of those individuals with, and that would be certainly discoverable information and being able to flesh out exactly what they meant in their emails, although I think it's pretty clear what they had indicated in those emails is their position and was their position at the time the agreement was negotiated. But what cannot be glossed over is the fact that, as counsel indicated, termination by the company without cause, paragraph 5C at page 4 of the contract, is absolutely triggered when Mr. Bergman is fired in January. And thereafter, when, as I believe probably occurred, the defendant realized what they had done, as we go to lengths to outline in the brief, they actually got a copy of the written contract from Mr. Bergman. That's what all of a sudden triggers in the recognition of the defendant. We best go a different path, because he explains to them, "You fired me, pay me my severance, and I'll leave right now." So it may be inconvenient for the defense narrative, but in what is before the court right now, the motion for summary disposition on the basis of no genuine issue of material fact, quite clearly the record indicates that, and taken in the light most favorable to Mr. Bergman, he was fired in January, and that firing, that termination triggering paragraph 5C was reiterated to him by his supervisor before his supervisor ultimately left employment at Maestro on February the 12th of the year in question. So with respect to this motion, and I didn't hear anything in oral argument, and I'll rely upon our brief with respect to the fact that clearly we outline a cause of action for breach of contract relative to the severance, relative to the commissions, relative to the time off work, but more significantly with respect to the question of whether or not there is a genuine issue of material fact. The termination in January clearly triggers 5C. And in fact, the only summary disposition that can be granted based on the record that exists right now is if the court were to say, if Maestro is not going to disagree that Mr. Bergman was fired in January, that he then is entitled to that severance by that paragraph at the time that termination existed and occurred. Relative to the argument with regards to the contract not having ambiguity on the severance, there is a question of fact on that, as we articulate in our brief and in the cases that we cite that reference in particular where there is a difference in opinion, and that's where and I will tell you that those emails have not yet been memorialized into affidavit. I think that they more fittingly should come before the court in the form of deposition testimony of those two gentlemen. But that's what we have, and it's pretty compelling and pretty strong without taking any discovery at this point in time. So I think the most appropriate outcomes should be a denial of the motion for summary disposition. We should certainly be permitted to take discovery on that issue. I suspect they're going to want to take Mr. Bergman's deposition with respect to the termination issue, and the substantive legal conclusion that the court would draw certainly can be raised again by either party, but certainly on those issues we should be able to take discovery, and that termination in January couldn't be more clear of what that triggered at that point in time. And in the defense isn't permitted to gloss over it by saying, well, yeah, but in the end we ended up paying him through the end of that term, because that's not certainly what the contract provides. Once they terminated, that triggered that language, that triggered the payment that was due to him, and you can package it any way that you want to if you're the defense, but it doesn't change that I suppose relatively inconvenient fact for the defense. I don't have anything further, Your Honor.
And so you don't dispute, I know your position is they fired him in January. I'll accept that as true. You don't dispute that he worked and was paid through June 30th?
That we've never disputed that he worked
Okay.
through.
Just checking.
Yeah, no. That part's clear.
Okay, thank you. I'm going to dispense with rebuttal argument. I just want to make clear, first of all, that this motion was brought under C8 and C10. In the briefing, it wasn't mentioned in oral argument, but in the briefing, the plaintiff seemed to think that the defendants were challenging the sufficiency of the allegations alone in the complaint. But the defendants are saying that the allegations in the complaint, together with the terms of the contract upon which the complaint is based, preclude recovery as a matter of law under C8. And then they brought it under C10 as well, because they added the February 2020 notice that has been referred to and discussed here, and an affidavit that just authenticates the notice. I actually don't think either one is necessary, but that's sort of beside the point at this point. So for the motion, though, I'm taking the allegations in the complaint as true, and I'm examining the contract as well. If the contract is unambiguous, and this is for a C8 motion, if it's unambiguous and it's dispositive, then a ruling can be made, and it should be made without regard to any parole evidence, any other type of evidence that has been submitted. If it's ambiguous, then that's a different story. The complaint, and this I think is important, acknowledges the contract of June 30th, 2015, and it attaches it and it makes it the basis of the allegations. The complaint also alleges that the defendants informed the plaintiff that he wouldn't be employed by them after June 30, 2020. And then the complaint alleges that the plaintiff was terminated without cause and is due compensation, commissions, and paid time off under paragraph 5C of the contract. Paragraph 2 of the contract provides that it is effective June 30, 2015, and it expires on the 3-year anniversary of that date. But it has an automatic 1-year renewal period, a repeated automatic 1-year renewal period, unless either party provides at least 30 days prior written notice of their intent not to renew. Furthermore, the initial term, that 3-year initial term, and the renewal terms, however many of them there are collectively referred to in the contract as the term. This paragraph 2 is, by its very terms, subject to earlier termination as provided in section 5 or paragraph 5. Paragraph 5C, which is what the complaint is based on, provides for compensation is if there is a termination without cause during the term. So the 5C specifically says termination by the company without cause. If the executive is terminated by the company without cause during the term, then the executive shall be entitled to receive, and then it lists various different kinds of compensation. The plaintiff claims that being terminated June 30, 2020 is a termination without cause during the term of the contract, and that's what the complaint alleges. The complaint alleges that the plaintiff was informed that he was terminated June 30, 2020. That it cannot possibly be true that that is a termination during the term of the contract, because each automatic renewal of 1 year put the term of the contract ending on June 30th of each year. The contract provides for at least 30 days of non-renewal, but that's really a non-issue because no one's claiming that the plaintiff didn't have 30 days. But the notice provision is just a notice provision. It doesn't matter whether the defendants gave notice in January, February, March, April, or May. The contract didn't terminate per the complaint and per the terms of the contract until June 30th. I mean, in terms of the notice of intent not to renew until June 30th. The complaint makes this very allegation that the defendants informed the plaintiff he would not be employed after June 30, 2020. That is the end of the term, and it's definitely not during the term of the contract. Now, the plaintiff has argued that he actually got fired in January. Well, I'm not going to dispute that. He may have been told in January that he was fired. But that is of no consequence to this ruling. The complaint, again, alleges that he was informed he would no longer be employed as of June 30, 2020. And the plaintiff doesn't dispute that he was indeed employed as of June 30, 2020. So while he may have been told you're fired, he was never fired. He worked to the end of the term. And that does not implicate paragraph 5C. The compensation that the plaintiff claims in the complaint that he's due is the compensation under paragraph 5C of the contract. And that's the compensation that comes when you're terminated during the term of the contract. There's no other allegation of any other contractual duty or breach other than under paragraph 5C. This contract is clear and unambiguous that 5C does not apply when a party elects not to renew at the end of the term. The compensation, again, that the plaintiff is claiming is due is only due under paragraph 5C. The complaint fails to state any claim for a breach of paragraph 5C of the contract. And the defendants, the contract is unambiguous, as I've already said. The court must interpret it as a matter of law. I've taken the allegations in the complaint as true. There's no factual development that could change that. And the complaint does fail to state a claim for breach of contract under paragraph 5C or entitlement to the compensation that's in paragraph 5C. And the defendant's motion for summary disposition is granted under C8.
Your Honor, if I may,
Ms.
Is that it?
Jackman, if you would. Let me just say this, I'll give you a chance then. Ms. Jackman, if you would prepare an order under the 7-day rule and submit it, all you have to say is that it's granted for the reasons stated under the record, and you should specify C8.
Your Honor, that's
Thank
to
you,
the
Your Honor, I'll do that. Sorry. Thank you. I'll do that.
Mr. Behan?
that is to the totality of the complaint, including the commissions.
Yes, the commissions come under 5C, yes. Well, let's put it this way. The complaint doesn't allege anything other than 5C. So if you believed that the commissions came under something else, then the complaint should have alleged it, but I'm going by what's alleged in the complaint.
Thank you, Your Honor.